Imagine knowing that 1 in 12 people wearing a court-ordered ankle monitor in your city has simply vanished.
Yeah, I mean, it paints a pretty terrifying picture for anyone living in that city.
Right. And we are looking at this today because, well, it is not just some hypothetical scenario.
No, not at all. It's happening right now.
Exactly. So we are jumping straight into the news hook here because the situation on the ground is just moving incredibly fast. Cook County Chief Judge Charles Beach just released a bombshell report, and it really shook up the local justice system.
Oh, absolutely. It was a massive wake-up call.
Right. So he revealed this staggering 8% AWOL rate, meaning, absent without leave in the county's electronic monitoring program.
8%.
Yeah, 8%. And to put the actual numbers to that percentage, out of 3,048 participants currently mandated to wear these devices, 244 individuals who are facing criminal charges are just completely unaccounted for.
Unbelievable. And, it is crucial to understand that this disclosure, it didn't just pop up during some routine audit.
All right, it's much darker than that.
Yeah, the numbers were released following a deeply tragic catalyst event. The fatal shooting of Chicago police officer John Bartholomew.
Such an awful tragedy.
It really is. And the suspect accused of pulling the trigger is a 7-time felon who had reportedly escaped from that very same ankle monitor program.
So you have this massive system failure catching national attention because of a tragedy. And for today's deep dive, we are going to figure out how the system actually got to this breaking point.
Yeah, we have a really solid stack of sources to unpack this.
Definitely. We're pulling from local news outlets who have been tracking the data, specifically CWB Chicago and CBS Chicago.
And we also have a detailed breakdown from a local criminal defense attorney's blog, which really helps us understand the mechanics of the rules, plus a major policy report from the Chicago Appleseed Center.
Right, the Appleseed Center for Fair Courts. So our mission today is to explore how this electronic monitoring system works on a technical level, why it ended up tracking people accused of violent felonies, and why writing strict new accountability rules is just failing in real time.
Yeah, and I think the best place to start is by looking at the roster itself.
Okay, let's do it.
Because hearing that 244 people are currently missing, it just forces you to ask who the system is actually tracking in the first place.
Exactly. Who are these people?
Well, the original design of electronic monitoring was fairly straightforward. It was built as a tool for individuals facing low-level nonviolent offenses.
Right. We were talking about nonviolent crimes like, simple drug possession or maybe retail theft.
Right. The core philosophy was simple. Keep nonviolent offenders out of a crowded county jail while they wait for their trial dates.
Which makes sense.
Yeah, it saved taxpayer money, it kept people connected to their families, and it allowed them to keep working. But if you look at the population on these monitors today, the system has experienced this massive shift in its basic purpose.
A total 180.
Completely. The program routinely handles people facing highly serious violent felony charges now.
Yeah, and the statistics from the April reports really highlight how drastic that shift is. Like, as of early April, the program was actively monitoring 21 people with pending murder cases.
21. That's just wild.
And another 13 people facing attempted murder charges.
And, the list just keeps going. The system also tracked 103 individuals charged with criminal sexual assault, 78 people charged with robbery, and 16 with pending carjacking cases.
Wow.
Yeah. You look at those numbers and you realize the risk profile is just light years away from someone waiting for a court date on a minor drug charge.
Right, because tracking an accused carjacker requires a very, very different level of vigilance than tracking someone caught with narcotics.
Exactly. Which makes perfect sense of why Cook County Sheriff Tom Dirt fought an absolute war to get his department out of the monitoring business.
Oh yeah, he was very vocal about that.
He was. He argued for years that the county was completely misusing the electronic monitoring system. His stance was incredibly clear. Violent offenders need to remain inside a physical jail, not walking around the streets wearing an ankle bracelet.
So he just pushed relentlessly to hand the entire program over to the courts.
Right. Sheriff Dart essentially looked at the reality of modern monitoring and decided his deputies should not carry that liability.
Which, from his perspective, I get. A sheriff manages a jail.
Exactly. Managing a physical jail is about containing people behind concrete walls. But when you put thousands of people on GPS monitors, you basically turn the entire county into a virtual jail.
And the sheriff is suddenly responsible for this invisible countywide perimeter.
Yeah, it was just a massive strain on law enforcement resources.
Wait, If the program tracks over 3,000 people and 8% are missing, do we know which specific charges those 244 missing people are facing?
Well, that is the most glaring unknown in this entire situation. The public simply does not know.
Wait, seriously?
Seriously.
Yeah.
Despite multiple direct requests from news outlets following the chief judge's disclosure, the chief judge's office has completely failed to answer that specific question.
Wow.
Yeah, we know those 244 people have pending criminal cases, but whether they are missing on a retail theft charge or an armed robbery charge remains a total mystery to the public.
That is deeply unsettling. So Sheriff Dart eventually wins his battle. He steps away from the program, and the entire system shifts hands. But changing the leadership created a massive gap in how the rules of the monitor are actually enforced.
A huge gap.
It really begs the question of who is actually watching the watchers.
Right. So the transition happened on April 1st, 2025. On that day, the Office of the Chief Judge took full responsibility for all new monitoring participants. To handle the daily operations, they utilized their pretrial and adult probation departments. The officials watching the screens and tracking the GPS dots changed from the sheriff's deputies to court personnel.
But the immediate friction there is that court personnel are probation workers. They are not law enforcement officers.
Right. And that is the systemic flaw that officials flagged the moment the transition happened.
Yeah, Cook County State's Attorney Eileen O'Neill Burke actually sent an internal memo to her staff, warning that this specific setup is a, quote, serious threat to public safety.
The serious threat.
Yeah. She argued that because court workers are not sworn police officers, their hands are completely tied when things go wrong. They cannot launch an investigation into a suspect's whereabouts.
Right.
They cannot seek escape charges on their own authority.
Right.
And they definitely cannot go out into the community to arrest people who cut off their monitors and run.
Exactly.
It's like hiring a referee for a football game, but telling them they can blow the whistle, but they can't actually throw a flag or stop the players.
That referee analogy captures the frustration perfectly. I mean, if an offender goes AWOL, the court staff's only real option is to pick up the phone and call 911.
Or just wait.
Right, or simply wait and present the violation to a judge at a later date. They are observers, not enforcers. And to make their job even harder, the rules they were trying to observe were incredibly complex under previous reform laws.
Oh, right. The Safety Act plays a huge role in setting up those complex rules.
It does. Under the original guidelines, a person had to be missing for 48 consecutive hours before they were officially considered an escapee.
48 hours.
Yeah, 2 full days. Plus, the law granted participants 16 hours a week of what they call essential movement.
Okay, so that allowed people to leave their homes for approved activities, right?
Yeah.
Like going to work, attending court, or grocery shopping.
Exactly.
But 48 hours is a massive window. If I'm an unarmed probation worker staring at a screen, I have to figure out if the GPS dot deviating from its path means the person is taking a detour to the grocery store during their essential movement, or if they are fleeing the state.
Yeah, it's a guessing game.
And I have to sit on that information for 2 full days before declaring a major violation.
You are describing the exact paralysis the system faced. The watchers had no power to act, and the rules forced them to wait.
Just a recipe for disaster.
Right. So, to bridge that enforcement gap without actually giving probation workers police badges, the new chief judge, Charles Beach, decided to change the timeline.
Right, he created a strict new protocol to force a faster response.
Exactly. But as we know, writing a new rule on paper and executing it in the real world are two wildly different things.
Yeah, the reality crash hit almost immediately.
It really did. In January 2026, Judge Beach implemented the 3-hour rule.
3 hours.
Yeah, he drastically lowered the threshold for an escape. Any unapproved absence of 3 hours, slashing it down from that original 48-hour mark, now automatically triggers a major violation.
Going from a 2-day waiting period to a 3-hour window is a massive shift in urgency.
Oh, totally. It requires a completely different operational tempo. The new rule demands 247 judicial review. Judges must review these major violations within 24 hours of the alert sounding. That means having judges on call over weekends and during holidays.
That's a huge logistical change.
And to handle the law enforcement side of things, the sheriff's office agreed to step back in and expedite any resulting arrest warrants so local police could act faster.
But when you look at the recent tragedies, the daily execution of this new rule just completely broke down.
Yeah, the system failed.
Like, take the case of Alfonso Talley, the individual accused of shooting Officer Bartholomew. The court records detail a terrifying timeline.
They really do.
His ankle monitor died because he failed to charge the battery, and he was missing from the system for more than 17 hours.
And under the new 3-hour rule, a 17-hour absence is a massive red flag.
Huge.
That violation should have been brought to a judge's attention well within the 24-hour mandate. But the court staff completely failed to follow the new rules.
Yeah.
The records show it took over 53 hours just to notify a judge that Tally was missing.
Over 53 hours. And it gets worse. Even after that 53-hour delay, the court never requested the expedited warrant from the sheriff's office.
Never even asked for it.
The system essentially noticed he was gone, waited 2 days to tell anyone, and then failed to ask the police for help finding him.
It's tragic. And you see a similar systemic breakdown in the case of Lawrence Reed.
Oh, right.
He is the individual who allegedly set a woman on fire on a CTA Blue Line train. The internal reports show he violated his monitor at least 5 times in the days leading up to the attack.
5 times.
Yes. The system was functioning. Alerts were physically sounding at the monitoring center just hours before the attack happened.
But again, no action was taken by the staff. The technology worked perfectly, but the human workflow completely collapsed. The alarms rang in an office, and a tragedy still occurred on a train.
And this brings up a massive point of friction from the perspective of the people actually wearing the monitors.
3 hours sounds incredibly strict. What if their battery just dies unexpectedly, or they get stuck in traffic, or they have a medical emergency?
Well, defense attorneys and reform advocates are sounding the alarm on that exact scenario.
Really?
Yeah. A local criminal defense lawyer's blog pointed out that the new 3-hour rule leaves 0 room for human error or technical glitches.
I can see that.
Ankle monitors require daily charging, usually by plugging into a wall for an hour or 2. So, a dead phone battery, a delayed transit bus, or a sudden trip to the emergency room triggers the exact same alarm as a deliberate escape.
Wow.
They warn that defendants are living in constant danger of being arrested and thrown in jail for simple, everyday misunderstandings.
So the system is catching technical glitches in the exact same net as violent fugitives.
Exactly.
That seems like a recipe for generating massive amounts of false alarms, which might explain why the monitoring center staff are so overwhelmed they miss the real threats.
Yeah, alarm fatigue is a very real phenomenon. I mean, if 90% of the alerts you see during a shift are just people forgetting their chargers, human nature dictates you might react slower when a genuine escape happens.
Right. And the Chicago Appleseed Center takes their criticism even further. They argue the entire foundation of the electronic monitoring program is deeply flawed, regardless of whether you use a 3-hour rule or a 48-hour rule.
Yeah, their policy report heavily highlights the human toll of the system.
What do they say?
They argue that the program heavily restricts basic movement and causes severe mental strain on the participants. I mean, imagine trying to hold down a job or care for a sick relative when your every movement is tracked, and being a few minutes late could result in an arrest warrant.
That sounds incredibly stressful. They point out the system routinely fails to consider those individual needs, like rotating work schedules or childcare responsibilities.
Right. And their ultimate conclusion is that electronic monitoring does not meaningfully shrink jail populations or help rehabilitate anyone. Instead, it just expands the physical jail into the community, placing constant surveillance on people who are still legally presumed innocent.
You end up with a system caught in this massive, multi-directional tug-of-war. We started this deep dive by looking at a genuinely stunning statistic: 244 missing people who are supposed to be tracked by the courts. And by looking at the sources, we uncovered a program handling violent felony charges it was never originally designed to manage.
Yeah, a system that relies on civilian court workers staring at screens, lacking any actual police powers to enforce the rules they're supposed to monitor.
And while leadership tried to fix the gap by writing incredibly strict new protocols like the 3-hour rule, the staff on the ground are clearly struggling to execute those rules.
Yeah, the friction between an overwhelming workload, rigid timelines, and the reality of technical glitches is leading to devastating public safety consequences.
It really is.
You know, thinking about all this underlying friction brings us to a final thought you should really mull over today.
Okay, what is it?
Think about the technology itself. We trust GPS technology implicitly in our daily lives, right?
Sure.
We use it to guide our cars flawlessly through traffic, and we track our food deliveries down to the exact minute.
We just expect the dot on the screen to be perfectly accurate.
Exactly. But when it comes to tracking human beings navigating the complexities of the criminal justice system, the technology is only as good as the human response time behind the screen.
That is such a good point.
It does not matter how advanced the ankle bracelet is or how precise the GPS satellite is. If an alarm rings in a monitoring center, but no one has the legal authority or the sheer speed to act on it, does the monitor even matter?
The technology only works if the system around it functions. That is definitely something to think about. Thank you for joining us on this deep dive. Keep questioning the systems around you, and we will catch you next time.